Thank you very much. So I changed the title slightly to be the 10 most common types of mistakes inventors make with their intellectual property. And this isn't just specific to UC inventors, that none of my inventors that I've worked with have actually made these mistakes, But we want to make sure that everybody knows where the pitfalls are so that they can build a portfolio, make sure it's robust, that they don't run into the problems that many other inventors run into, and then find themselves with a very diminished portfolio and all that for developing the technology. So right now we have a pop quiz because we want to see how good the someone needs effectiveness as a teacher. So if everybody can answer these questions, I believe that they're doing it online. An abstract on the internet is not a publication that can be used to defeat novelty. True or false? The answer.
Yes.
Yeah.
There are paper ones for attendees in the room.
So please answer.
We're going to do it secretly and quietly.
Everybody answer the question, true or false? Am I going on to the next question? Do people log in their answers yet?
Okay.
How are we doing?
We're having technical difficulties. 1 minute. Mute. Okay.
What we need
Okay.
is an inventor
Yes.
to make this process efficient.
Okay.
That's okay, you get extra time to answer. So, next question. Your own abstract and or poster session is a publication that can be used to defeat the novelty of your own invention. True or false? Your own materials can be used against you.
We'll give you a little bit of time to think about this. Okay.
Are we ready?
Yes, that's
Next
fine.
question. In order to get a patent claim to a particular
Whoa, what
embodiment,
is this?
one must have supporting experimental data. True or false? The next question, the final question, question number 4. Whoops. I'm pressing the wrong button. That's me, operator error. If one makes an inventive contribution to just a part of the patent claim, she is an inventor. True or false? Gotta make sure everybody answers these questions. Everybody logged in their answers?
Yeah, I'm trying to see. It says your webinar will begin shortly for some people.
We need better technology. Inventions can do this kind of thing.
So everybody on the webinar, we apologize. We're having technical difficulties. Earlier we were talking about how many PhDs it takes to brew a cup of coffee because there was some technical difficulties with that too, but we'll get it figured out.
I think we should proceed.
Okay.
Okay.
All right, so now for the fun stuff. The very first mistake, that most common mistake, is not staying informed of patent law basics. I am not going to give you the whole patent law treatise. It's a lot of very thick, dull law, but these are the basics, or well, the next slide is. Because you need to know the patent law basics, because most mistakes could have been avoided by understanding just the very simple, and I'll tell you in 7 slides what those basic little rules are. And this is a summary of it. Who can get a patent? First inventor to file. We are under a first to file system now with inventors, so it's very important that you disclose your invention to your tech transfer office. If you're UC, you go to UC OIP here at LA, if you're at LA, but each office has their own, university section or campus, there we go. Campus has their own tech transfer office. Visit them, talk with them. They have great resources. So I put down the section numbers right along the side of these little patent law basics, because I'm sure many of you who have worked with patent attorneys, the patent attorneys start talking about, oh, section 101, section 102, and you're thinking, what is this? Well, you really don't need to know what the section number is, but if you ever want to know what the patent attorney is saying, 101 goes to utility and eligibility, 102, novelty, 103, non-obviousness, 112 deals with the specification and claims, the actual application, how it's written, and then we have a Rule 156, which is the duty to disclose. And so I'm going to briefly go over those and what they mean, because that sets up all of the common mistakes that are made. So the first one, utility and eligibility. What is patent eligible subject matter? A lot of you guys have heard that it's very controversial now. We had the Supreme Court come out with some decisions that are pretty problematic to most. But basically, you can get patent claims to processes, machines, articles of manufacture, compositions of matter, and, well, as for processes, method claims, diagnostic methods, questionable whether or not we can get those anymore. Machines, well, the Supreme Court has come out with some pretty tough cases, decisions where computer software, computer systems, those are all at risk and questionable whether or not they're patent eligible. And then you have compositions of matter. Now, everybody has probably heard something about myriad and that the breast cancer gene, and we cannot get patent claims to isolated genes. Other biomolecules are now possibly at risk. It's problematic if you ask your patent attorney or a patent attorney what is patent eligible. They will say, not really sure anymore, because we're not really sure what is patent eligible anymore. So basically with utility and eligibility, you can't get any inoperable inventions patented. No inventions, and this is especially important for therapeutics, we'll leave diagnostics aside, but medical treatments, therapeutics, you can't get things that have an incredible utility. There has to be some showing of usefulness. And so I bring up this example. You can't actually get a patent claim to preventing cancer. You can get treating cancer. But this is how patent attorneys work, that it's very specific about the words, because with preventing cancer, there is no actual experiment or model organism that you can set up the experiment to definitively show each and every time you completely prevent cancer. And that's why the Patent Office doesn't like claim language like that. Can't get immoral or mischievous inventions patented. No isolated genes in cloned animals. Once again, there was can't get Dolly the sheep patented. Novelty. So this is where we get into the real more substantive stuff about what is patentable. And so patent protection must be pursued before being patented, described in a printed publication, in public use, on sale, or otherwise made available to the public. There are exceptions, but for everybody, I just want them to think and act like you have to have absolute novelty like the rest of the world. And so that means pursue patent protection before disclosing, before submitting your journal article, all of that. Just make sure that you pursue it before, and that means talking to your tech transfer office and telling them, letting them know when you're planning on doing certain things. And so with novelty, the exact same invention being claimed, the exact same invention being claimed must not be anticipated in the prior art. So it's like, if it's one-to-one correlation with your claim, and that's what was in the prior art, you can't get a patent claim to that because it lacks novelty. And so if the prior art discloses compound X, you can't get a patent claim on compound X. Prior art does not, and so the next example, prior art does not disclose using compound X to treat disease Y. Well, then you might be able to get a patent claim to a method of treating for that disease if the prior art doesn't disclose any type of correlation to that disease and that it has some therapeutic value in treating it. And one of the two, I guess, interesting aspects of novelty that we run into with investigators is that a species anticipates a genus. A genus does not anticipate a species, but a species anticipates a genus. So if there is a compound that, in the prior art, and you're trying to claim a broad, general structural formula class of compounds, but there's this one little compound, a very specific compound that's in the prior art, that anticipates the genus that you're trying to claim. However, the reverse is that if the prior art only discloses a genus, you might be able to get compound claims to very specific compounds that, even though that they fall within that genus. There's some other issues there, but this is just the basics of patent law so that I don't bore you to death. And the next issue is anticipation by inherency. This is, especially in biotech, we run into issues of anticipation by inherency. So, for example, prior art discloses a method for treating a tumor by administering compound X. The inventors discover that compound X induces apoptosis in tumor cells. And they come to the tech transfer office and the attorney, saying, I want to get a patent claim to method of inducing apoptosis with compound X. Well, you can't get that patent claim because you will get a rejection called anticipation by inherency, because it's inherent that when that compound was used in the prior art to treat tumors, that it caused apoptosis in the tumor cells. So then the next patent law basic is non-obvious. So your patent, your claimed invention has to be non-obvious. One cannot obtain a patent on an invention where the differences between your invention and the prior art would have been obvious to one of ordinary skill in the art. And one of ordinary skill in the art is a hypothetical person made up by us attorneys. It's not the inventor. It's really akin to your colleagues who are not, researching with you in your lab that you're working with, who might be other inventors, because inventors are not your person of ordinary skill in the art. It's your other colleagues who would understand when you talk with them what you're doing. You tell them, you talk all the science with them, and they understand. So that's the person of ordinary skill in the art. Now, there must be some suggestion or motivation to modify, combine the prior art that the examiner found, that's out there, to result in your invention with a reasonable likelihood of success. It doesn't matter what the inventor himself thinks, whether or not he thought it was going to be obvious, or it doesn't matter. But remember, what the inventor yourself says or thinks about your own invention can be used against you. And that's key for later on. So for whether or not it's obvious, it doesn't matter whether, that the inventor said that I don't think it's obvious. It wouldn't have been obvious to other people. It wasn't obvious to me, and that, it wasn't obvious. But if he admits, well, yeah, it's pretty obvious, people would think it's obvious, that's a problem then. So the specification and claims, that's what the patent application. That's where we work with, the patent attorney. You write about the invention, the experiments, and then the patent attorney writes some claims towards the invention, and you try to define the metes and bounds of what you're trying to claim. And the patent law says that your claims must be clear and definite. Your specification and claims must have sufficient written description and enabling support for what you are claiming. And the most important thing is that after that patent application is filed, you cannot add information, add material, data to the specification or claims. And if you want to amend the claims later on, like say you enter in prosecution where you argue for patentability of your claimed invention, if you want to amend them later on in order to address some rejection the examiner made, it has to have support in the original application as filed. And so it's very important that inventors, read the application, work with the attorney, and make sure that everything that they have is in there to the best of what they can, because later on you can't amend the claims in such a way that it wasn't supported by the specification. Final slide on this patent law stuff. Duty of disclosure. Everybody involved in the preparation, prosecution, anybody who has an interest in that patent application, that invention, has a duty of disclosure. This means that we have to be upright with the patent office to tell them about what prior art is out there, what information might be material to patentability, meaning, perhaps there's, it's questionable even whether or not there is sufficient enablement, that there's issues, and that is in some, like, say, reference, that we need to disclose that to the patent office, because if we don't, the patent that eventually issues could be basically killed, voided. And so this is very important. And this duty of disclosure is from beginning to end. It's to when the patent actually finally issues, and then that is when the duty of disclosure ends. So you need to keep the tech transfer office, the patent attorney, informed of any research articles, prior art information, pamphlets, anything out in the public that you come across and become aware of that might be material to the patentability. And patentability are all those other sections that we talked about before. 101, utility and eligibility, 102, and novelty anticipation, 103, obviousness, 112, best mode, written description, and enablement. So here are some fantastic resources. Every once in a while, I check out the resources that some of my clients have, and I recently was looking at UCLA OIP's information for inventors, and great materials. I really have to say, really fabulous materials. Everybody should look at them. And so the hyperlinks are right there. It tells you about patents, the patent process, the timing. To your heart's desire, you can find information there. The other, I believe it's the other one, the other pamphlet that tells you about your responsibilities and duties as an employee, what you're supposed to do is in disclosing your inventions. And there is a little bit in there about how, inventorship and royalties and how all that is determined. And I know that's a question that a lot of PIs within the university system ask about. So take a look at them. They're very, very easy to read, not a lot of attorney clutter. So, and talk to your tech transfer officer. They want you to come talk to them. They want to know what you're doing. They want you to come ask questions. Just drop in every once in a while, talk to them. And then your patent attorney assigned to the case. Let them know what's going on. Keep them
The broadcast is now starting. All attendees are in listen-only mode.
So, next common mistake, not understanding the meaning of inventorship. This is one of the biggest problems or questions that many PIs, scientists, inventors have. What is inventorship? Inventorship is not authorship. It's a legal determination based on the claims, and it's the job of the patent attorney. An inventor is one who contributes to the conception of at least one claim. Conception is complete where one of ordinary skill in the art, again we have this hypothetical legal person, one of ordinary skill in the art can practice the invention without extensive research or experimentation. Conception is a mental act, and so therefore proof of such requires corroboration. Sometimes actual reduction to practice is necessary for conception. So there are some types of inventions where, you know, it doesn't quite get to conception until you actually do the experiment, and voila, there it is. Joint inventorship requires collaboration on the final conception of the claimed invention. You need not have physically worked together or at the same time. You need not have made the same type or amount of contribution. And this is one that is probably the cause for a lot of problems with inventors and people who are deemed not to be inventors, is that one can spend so much time and energy, blood, sweat, and tears, and their efforts, unfortunately, are not an inventive contribution, and that causes so much heartache. And when they see another person who's actually named as an inventor, and they might have just like mixed A and B together and voila, and they were named as an inventor, and they don't understand, well, this is the reason. It's not about the type or amount of contribution. And there's great big huge treatises on this definition of inventorship, what makes it inventorship, and it can get pretty complicated. It's best, it's for the attorney to do it, make the determination. If there's ever any issue, let the TTO know about it and tell your patent attorney, because we want to make sure that it's right. Because if you don't get it right, it can kill the patent. Your patent that eventually issues could be invalid. So also, with inventorship, you need not have made an inventive contribution to all the claims in the patent application. So it may be enough for just a part of a claim, and that person, if they provided an inventive contribution to just a part of a claim, that they are an inventor. You're not an inventor if you only provided an idea or suggested a result, a desired result without anything more. If you just provided background data, general information, resources, funding, and nothing else. If you merely followed instructions, and so this is where there's somebody in the lab who spent hours and hours, and they did all this work that they were told to do, and it turns out that they're not an inventor. So also, you're not an inventor if you indicated what won't work without any indication as to what will work. That does not make an inventor. And so once again, inventorship is so extremely important. It's important to make sure that we get it right, because if it's not right, it can invalidate the patent that eventually issues. And so then everybody's work is meaningless. If there's squabbles and it's not right, and that there's misjoinder, that it can be very bad, and then just render all that hard work for years just meaningless. The third most this actually isn't in order. It just flowed as in topical, so topics. So it's not like the third most error, but erroneously thinking one's own actions can't be used against your own invention. Your own actions can be used against your own invention. Remember, novelty and non-obviousness, those requirements for patentability, that your own actions can be used against you to defeat novelty, to use in combination with some other prior art references to result in an obviousness rejection. One of the big ones that we often run into, and OIP runs into, are consulting agreements. Consulting agreements can be very problematic. They often contain clauses that could be interpreted as a sale, offer to sale, In addition, they can contain terms that conflict with your obligations to your research institution. So if you want to enter into a consulting agreement, go talk with your tech transfer office. Tell them what's going on, show it to them, and they can help you with it. And they can also point out, possible areas of concern that you want to look into. Your own actions can be used to reduce the IP and commercial viability of your invention. And so where we run into that is talking with companies. A lot of times inventors, especially ones who are the ones that I actually really like, who are very involved in their invention and they want to commercialize it and get it out there, and they're proactive. Well, they often run into issues of being very proactive in talking to companies first before talking to the tech transfer office, and then we run into problems. And the problems that you run into are that it can contaminate the IP rights, the company might be a little bit problematic, and that they go, oh, they take your idea and run with it, and then they don't need you anymore, don't want you or license your invention because you gave them the idea and they started working with it themselves, and so they sidestep you. So don't do it. Talk to your tech transfer office. They can, before you talk to the company, set up a non-disclosure agreement, file a provisional patent application to make a record of what you had and what's your invention in case there is a subsequent issue. So talk to your tech transfer person. They're really great. UCLA has a fine group of people. They're really on the ball, and they don't bite, not like some patent attorneys. So talk to them. Your own actions can be used as prior art. Abstracts. A lot of scientists think, oh, it's an abstract. It doesn't have anything in there. It doesn't have any of the data in there, nothing. How can that be prior art? Well, in patent law land, it can be used against you, and very problematic. We often run into our inventors' own abstracts that are used to defeat novelty and used for obviousness rejections, and so it's a problem. Student theses, those can be problems. The abstracts can be published, and then also if one copy is just available, like just filed away in some dusty old library, that could be considered a publication. So once again, don't do until you talk to your tech transfer person and they file for protection or they make a decision, because it can be problematic. Just as abstracts can be problematic, poster sessions. Poster sessions, you go to a scientific conference, you have the poster session, maybe even it's not published in a journal, like some conferences, then, at least put the abstract in there later on, but poster sessions are out in the public disclosure can be a problem. Don't do until you talk to your tech transfer office. Seminars too, even seminars within your own research institution, because there may not be some confidentiality, like obligations in place, and there's people, I was going to say non-UC people, but then tried to change it to entity. But there may be like people who are not part of your research institution who are then considered public, and it's public disclosure because they don't have certain confidentiality obligations. Journal articles. Your own journal articles can be used against you. Problem is a lot of times you run into a very prolific inventor. They write a lot, they produce a lot. We love it. I mean, everybody loves it. The university loves it, but in patent law land, then we're staring at a lot of their own art that can be used against them. And we need to know about that too. So just make sure you inform us about your own actions so that we can deal with it. And tell your TTO before submitting and presenting. Actually ask your TTO even after an application was filed. A lot of inventors think, okay, well, we already filed a patent application on my research, on my invention. We filed a patent application, and they have like additional, data, information that they want to, provide at a poster session, and they think it's okay because they had a patent application that was filed, you know, like maybe 6 months ago. But no, we need to review the new data and make sure that it's covered, it's encompassed in the patent application that was previously filed. Because if we don't, you might lose absolute novelty, you might lose novelty. It could be used against your future inventions. So make sure that you let us know about it and we talk about it. Another problem, you know, type of error is inadvertently opening mouth and inserting foot. And the reason for this is because it causes foot and mouth disease. Using patent legalese in your writings can lead to disease. Avoid words like novel, obvious, enabled. That often I find inventors that I work with, you know, after they learn some of the patent law basics, then somehow it starts creeping into their writings. Well, when they use it, they're using it in a different way. They're not using it in the legal patent law sense. And, you know, even though they're using it in a different way, it can be interpreted in a very bad way against your own invention. So just avoid those words. Find out another word that you can use. I actually did, in preparation of this presentation, I looked on PubMed and I just typed in novel. The first article that I pulled up, and it was a short journal article. It had over 100 uses of novel in it. I was like, oh my goodness, don't do it. I don't want any of my inventors to use those words. Don't use the words. Now, another problem that I've seen is grabbing the examiner's hand and walking down the path of obviousness. And it's like, yay, let's just walk down. I'll tell you how we got there. And they, you know, in a lot of times in journal articles, you see this whole setup before the invention, you know, leading into well, how it resulted in invention, well, this and that, and then because of X, you know, says this, and Y indicates this, we decided to do this because, of course, you know, this was the result that we were expecting. Well, that can be used against you. Avoid inserting references in reference citations in parts of disclosure that relates specific to your invention. And often, you know, like a good, you know, scientist wants to, you know, has to, you know, provide credit where credit's due. But often I find that those citations are slightly inserted in the wrong place, such that it looks like you're almost saying that, well, they suggested this part of our invention, and that can be bad. Don't do it. Think about where you're putting those references. And the best thing to do is to try to, and I know people want grant money, they want to like justify, you know, their invention, they want to prove, you know, how they got to their scientific result, you know, their finding. And so it's hard, but if a patent attorney had their way, it would be, well, you slipped in the shower and you bumped your head and it was an aha moment, and, you know, that's how you know, it just happened. But, you know, we all know that that doesn't necessarily happen. It doesn't work in the real world. But try to limit grabbing the examiner's hand and saying, let's go down this path, because it can lead to death. So avoid putting certain things in writing, in emails, unless specifically asked by your patent attorney. Often I find inventors, they want to be helpful, they want to be involved, and we have an office action, you know, where the examiner is saying this is obvious and these are the reasons why the examiner thinks so, and before the patent attorney can even like get to the inventor and talk on the phone first, the inventor writes a response, sends it to the patent attorney, and it really turns out to be making a case for obviousness. There is a very fine line between obviousness and non-obviousness. It's just the flip side, and it's the way that one presents it that can just make the difference. And so don't put anything in writing. And if there's any doubt, just call up the patent attorney, call up the TTO, talk about it, and then we'll ask you, oh, could you send me this and tell me this, like, that, and don't try to answer questions that they didn't ask, or be, you know, extra helpful and provide even more, because it could be a problem. Talk to them first. So another type of mistake: not providing information or waiting until the last minute. Again, failing to disclose all publications, yours and others, related to the invention decreases the chances of securing the best possible IP protection. If we know about something, we can usually address it before it becomes an issue. If we know about it at the time we're writing the application, we can usually write in language in the specification and the claims to try to carve that out. And remember, you have to have support for what you want to claim and the limitations of your claim. You have to have support in the original application. So if we don't know about it, we can't set up that type of language for the downstream prosecution. Also, if you don't tell us about something, if you don't tell us about an upcoming presentation, an upcoming manuscript that's going to be published because it was just accepted, it may even be on the internet already, we can't do anything after the fact. So if we know about it beforehand, we could file provisional, and then try to minimize the risk of losing novelty or creating some big problems for us in that. Again, if you don't disclose information that's related to your invention that you know of, it could violate the duty of disclosure. I gotta hurry up, I know, sorry. And so, really, when you have a duty of disclosure, and hiding the ball only puts all of us behind the 8 ball. There's some things that we can't ever fix, so don't try to hide the ball on us, just tell us, and we can work with it. Last minute information increases the costs, the problems. It causes us attorneys to have foot and mouth disease because we might not have all the information, and then it turns out, last minute, we don't have enough time to really, flesh it out and think about it. So also, a lot of decisions are made before we get that last minute information. One of the typical ones is if we don't have information from an inventor, they're not very responsive, and it's a questionable case. Sometimes the decision to abandon the case is made before we get that last minute information, and then the decision's already made. So, but remember, last minute information is better than no information. Thinking narrowly, I gotta hurry up. Thinking narrowly is another problem. Narrow thinking can result in narrow patent protection. So there's a difference between science and what, the reviewers of journal articles, and then there's patent law land. Patent law land, you can dream a little. So dream a little, but provide prophetic examples, provide alternatives, things that can be supported by extrapolation. Think a little bit like what would be all the different tweaks and all of that stuff. And tell your patent attorney, because that gives breadth to the patent that eventually issues it. It makes it more valuable. But be realistic. Don't try to claim more than what you could get, or more than, you can't claim the world. It's already out there. But you also have to worry about enablement. So make sure that everything that you want to try to claim is actually enabled by your research. And then, what can be extrapolated with a reasonable expectation of success. Being unrealistic is another problem. Another type of mistake that causes problems. You must be realistic about the goals of patent protection. Patents help make inventions commercially viable. A patent is the right to exclude, not the right to practice. Remember that, you may get a patent on, something, but another's rights may exclude one from actually practicing that. And so often that may be the reason why your invention isn't pursued for patent protection, because there's going to be global rights where it's just not commercially viable. It doesn't mean that your science isn't worthy. So that's not the contemplation. Few patents result in one getting rich with royalties, but I've often seen how greediness causes problems. I liken greediness to hubris. It causes downfall, and it usually squabbling, and then, you know, it's just too big of a mess to where nobody wants to touch it because it just is problematic. So one of the big issues is being head over heels in love with your own invention. That results in people not being very objective about the arguments that can be made, or helpful about what something discloses. So try to be objective, understand that it's not an attack on your invention, and we're just trying to figure out what's best. So failing to involve the technology transfer office, big problem, one of the biggest problems, because the result is you get no patent. Gotta involve them, talk to them. Putting too much faith in the patent attorney. What? Yeah, it can happen. You know, patent attorneys don't know everything. Patent attorneys know the law, and even some, maybe, you know, it's questionable. But you are the expert on your own invention. For most seasoned attorneys, it's at least 10 years since they've been in the lab. And your invention should be novel and unobvious to them. And so it should be completely new to the patent attorney. Don't be afraid to talk with your patent attorney. Ask them questions. And if you don't quite get the answer, challenge them. I've found that in my practice that when there's been an inventor insistent about something, and he keeps like going, but, and I find out, I go, okay, well, what's going on here? I find out, oh, this is really, we need to put that in there. This relates to that, and we got to cover this. And so it's like we don't know what to ask sometimes because we don't have all the information, we don't have the facts. So if you feel uncomfortable about something, ask your patent attorney, talk with them, challenge them. If they're not listening to you, if you don't have a good dialogue or rapport with them, tell your TTO person. Because that's not, that nobody wants that, it's not going to result in good patent protection. Not being involved all the way, from beginning to end, that's another big problem. A lot of inventors think, oh, well, we filed the patent application, and so I'm done. No, it doesn't end there. After a couple of years, then we start examination, we have rejections, we've got to respond to them. And the most valuable, robust patents result in the inventors from being actively involved from beginning to end. Read the application drafts that you get from your patent attorneys. Read the claims. The claims are most important. A lot of inventors will skip over the claims because they're reading the experimental section and they think, oh yeah, the patent attorney has the claims covered. But you know, you got to read the claims and understand the claims. And if you don't understand the claims and what they mean and what they're trying to cover, ask the patent attorney. Because it may be that an important aspect of your invention isn't covered, but the patent attorney, remember the last slide, that they don't necessarily know everything. So read the claims, spend time on understanding the claims and the amendments to the claims. Don't just like go, okay, that's fine, whatever, you know best, but read them, understand them. Be involved with the patent prosecution, preparation, and keep the TTO and the patent attorney informed of your further research and developments and future interests, and make sure you provide us updated contact information. We find this a lot with you know, the PhD candidates and people working in a lab with somebody else, and then they leave, you know, after a few years and they're gone, and then we're like, well, where are they? Because we actually need them. We need them to sign certain things sometimes. We need them for input information. So keep everybody up to date with your contact information. And so now we have the final exam. Final exam. An abstract on the internet is not, and we have to do this because we want to know how well I did here, which hopefully we get these right. But so final exam question number 1. Abstract on the internet is not a publication that can be used to defeat novelty. True or false? Yay, have everybody logged in? False. Yay, correct. All right, next question. Your own abstract and or poster session is a publication that can be used to defeat novelty of your own invention. True or false?
True.
Everybody logged in on the internet? very good. True. So question 3. In order to get a patent claim to a particular embodiment, one must have supporting experimental data. True or false? Everybody logged in? False! False! You don't have to have, like, for each and every claim and embodiments that you're claiming, actual experimental evidence. You could have like other evidence that supports, and then you can make an extrapolation. And so this is where you want to, you know, dream a little, try to claim a little bit more, and don't think that because you don't have the data yet that, oh, well, we can't go to the TTO yet, we can't go to the tech transfer office because we just haven't proved everything about it. No, it's a little bit more flexible with patent law. Final exam, well, got final exam question number 4, and then we'll have questions after. If one makes an inventive contribution to just a part of a patent claim, she is an inventor. True or false?
True. Yes.
It's a little bit vague.
It's sort of ambiguous question.
Yeah, true.
True.
True. Can, you know, because there's like different, it depends. Yeah, it is a little bit vague.
On the part.
Yeah, part of a patent claim, a claim, but you know, there's like sometimes parts of claims that do actually make for an inventor. So, if anybody has questions, here's the question and answer time. Hopefully, I have the answers. I mean, you know, Dr. Gans was saying that all questions would be answered, but.
Okay, I have a question. For the purposes of a patent application, what constitutes an internal conference? How do we know what's a conference that is protected from, in other words, it's not a public disclosure. That conference does not constitute a public disclosure.
It's situational often. I mean, lab meetings, or it's just the people working in your lab, and they're all really, you know, part of the UC system under, you know, the duty of confidentiality within your own lab. They have responsibilities, university. I mean, those type of meetings would be internal. But when you have maybe, say, you know, invitees from outside your lab, from other places, that may be a problem, and you want to talk to the TTO to explain the particular situation, who would be coming, what is being disclosed, and you know.
And then we simply have to subject them to a non-disclosure agreement.
Yeah, that may be one of the things that's done
Yeah.
To protect that.
Yeah. The way you talked about publications is sort of against the scientific ethics of identifying where your ideas came from, the prior art, describing in detail what it is you could do so it's replicable. It just made me feel a little uncomfortable about how you would write a paper if you're thinking of having something patentable.
Exactly, and so that's where it would be really helpful for you to talk to the TTO first, so we could actually apply for the patent application first, and then also the patent attorney would, you know, review your manuscript too, and like say, you know, this kind of verbiage is a little bit problematic, but so that's why I put like right here, you know, avoid writing, you know, because so-and-so did this, and X suggests. Suggest is another bad word, but X suggests this. You know, we assumed that this would work, so we did it. I mean, you can leave out the, you know, we assumed, you know, or it's certain words, so it's just not so blatant that you're, you know, this was obvious, and so we did it. And it is, it's a balance of you know, that what you have to do in the scientific community with grants and journal articles. And we understand that, but it's, you know, try to avoid the words. I know and try to avoid those things, but I know that there's cases where it's not so easy to do.
What is a threshold for the institution to have IP rights over an
inventor's invention.
This is why we have people from OIP here to answer certain questions.
What was the question again?
What is the threshold for the institution to have IP rights over an invention?
So let me dig in a little bit. When you say threshold, you mean ownership?
Well, what if
royalties?
No, specifically with regards to employment status. Does an individual have to be an employee of the institution for the institution to have IP rights?
Not necessarily. Students, for example. Your graduate students, your postdocs. Usually undergrads are not party to that. But anything that's generated under the UCL umbrella.
What does that mean?
Students and faculty. It can also go to researchers.
So when you say faculty, if those faculty were hired on as employees,
correct,
but they haven't been paid by UC, how does that sort of make the argument void?
Well, you sign an employment contract with the University of California, so maybe paid or unpaid.
Well, it's being used with UC resources related to generator. If UC resources, sorry, that like, you know, lab equipment, you know, lab space, materials were used to make the invention, then that can fall under the domain of UC from what I understand with UC policy.
Is UC policy government policy?
It's state policy.
It's state
by
policy.
government, yes.
Sounds good. Thank you.
A quick one. Obviously the patent office has got to follow this is behind, and the points you're saying, you keep saying talk to the CTO officer, but there are so many of us giving seminars all the time. There's no way.
Right.
So when we give, and now with many of the grants, these are tax dollars paying for it, but we're doing inventive stuff and we come up with new ideas. So we have conference calls that are all on the same grant, but they're at Hopkins and they're at Pittsburgh, and we're sharing our new ideas. So it's same as a lab meeting, but now you got 3 institutions, 4 institutions. And part of the part is that we put slides up, and so I'm on 5 NIH committees that are to try to define where the future is going, and they want all of our ideas. And part of my job of being that is to put a slide together. Even if I put PDFs, it still shows up. So all those count as prior art.
Well, it's surprising how efficient and effective the tech transfer office is, because they have all these worker bee patent attorneys there where often we get last minute, hey, we just found out an inventor is presenting, is disclosing this or doing this, can you file a provisional application? And we love it because it means, you know, work for us, you know, hungry attorneys.
It means work for us.
But
we have to fill out the form.
The form is pretty short, actually, and I've seen half filled out forms. It is also, from what I understand with UC policy, after reading the stuff, it is a responsibility, a duty that's set forth in
it brings into conflict our academic obligations versus the dollar-making obligations, and there's time. If I have 8 presentations this week and I'm going to give 4 different things, there's just no way that
I beg to disagree, because you already did that PowerPoint, and all I've seen invention disclosure forms where it just had the inventors listed, their names. I had to go look up their other information and stuff, but it was, you know, just slapped together in the same email with the poster session, and then the TTO, they were made aware of it, and then they sent it to me and said, hey, this is happening tomorrow, can you file it today? So one email.
Yeah, our advice is in those circumstances, it sounds like, in essence, your conversations with the NIH are indeed confidential. Your conversations with other faculty members is the act of conception, the idea of producing these inventions. So in essence, everyone is an inventor, perhaps. And if you distill that down into a very small conception idea, send it to us in an email, and we'll begin to look at it and consider it as an invention. We can fairly get a patent application in a provisional very quickly. So our advice is to file first, publish later. And you're absolutely correct. There is a kind of a contrary objective between patent and academic freedom. And you try to basically marry the two where you can accommodate both.
Every time I have to fill out a invention report, it takes more than a minute.
Yeah. I have two questions from remote participants. First one is, does an IP have to specifically address a particular disease condition to make the claim?
Does it what?
Does there have to be an application to a specific disease condition if you apply for a patent? Does there have to be
Oh, okay. So
or can it be a general?
Right. It depends. There are different. Once again, remember the different types of patent claims, patent eligible subject matter, methods, compositions. So if maybe the composition or compound is already out there, well, you can't get a claim to that. So you're really looking at a treatment method.
Yes.
And so if you're looking to get a claim to a method of treating something or a particular application, then you do have to show data and evidence to support the fact that you actually are effectively treating that particular
But you could have, for example, a patent on a new thermometer or a new blood pressure device that applies to many, many different diseases.
Absolutely.
Yeah.
I've seen patent applications where the uses are several pages long. I mean, everything you can dream about.
And that's where I'm saying, don't be so greedy, because greed, when you try to list all those things that you haven't supported, one, we're not going to be able to get patent claims to all of those because of enablement. But that application, once it becomes published in public, then all of those listings of disease indications that you never really showed, well, that can actually be used against you then, even though you never provided evidence for it. So don't be, too greedy and try to claim everything when you don't have evidence for it.
And then one more question, is software generally patentable or not?
Questionable, but generally software itself, the direction that we're going is not. All the court decisions that have come out since the major software Supreme Court decision called Alice has invalidated the patents. I don't want people to just take that on its face and say, okay, well, mine's the software, it's not patentable, so I'm not even going to talk to the TTO or tell anybody about it, because it's not necessarily the case, and it's something that we have to flesh out and look into. So no, but it is challenging. Just talk to us, come tell us about it so we can figure that out, because it's case by case.
Next question is, what if a poster is presented in a foreign country? Can it prevent you from patenting in the US?
Yes, it can. It doesn't matter where, anywhere in the world, it can be used to defeat novelty, it can be used for obviousness.
So I have one more question. So the question is, if a faculty or students, or postdoctoral fellow or anybody research, if they invented something, they did some work that is patentable, and they file application for a patent, and after certain times, if that person leave the university, what will happen to that patent?
So if a person who is in the middle of filing leaves and works for another institution, how do we deal with that?
The technology is often owned by the university still, because it was created at the research institution, a particular research institution.
So as an owner of the intellectual property, we are responsible for maintaining the intellectual property and going through it, as Susan said, for prosecution. So we spend a lot of time chasing down ex-postdocs around the world, wherever they are, to get declarations and assignments to that intellectual property. I mean, we found people that have actually died in China, and we have to secure their trust, their wives, their children, in order to get that assignment, basically. So we spend a lot of time in doing that. So the invention itself still resolves, and we have to do our best to get those assignments and declarations.
So the follow-up question is, if that faculty leave the university, so is the patent university office, TTO office can file the patent?
Yes.
They can file the patent,
Yes.
and all the expenses will be covered by the university?
Yes.
Suzannah, will you explain that even though software may not be patentable, it's copyrightable?
Oh, yeah, very good point.
It is what?
I tend to forget about
Copyrightable.
The work itself is basically identified as property.
It's intellectual property.
Right. And you copyright it, just like you copyright an article. Basically, you can do the same.
So there's trade secrets, trademarks, copyrights, know-how, and patents, and all of those are considered under the domain intellectual property. And so software, even though it might not be patent eligible, it is copyrightable. And so that's something that OIP may want to look into, and if they decide not to pursue patent protection on it.
The software, what we like to see is software, basically written for a device that does something. And that is patentable. That could be part of the patent, basically. But on itself, as a sole standing, it's questionable. So if you have an EKG machine or something that you've programmed to do something, then that is indeed part of the patent. It's patentable.
Suzannah, one more question. So my understanding was that the patent has to be sufficient disclosure for someone else to be able to reproduce what you did.
Yes.
Isn't that the quid pro
Yes.
quo? And that's still the case.
And that's still the case, and that's how I present the issue of enablement to inventors, and I kind of glossed over that. But so a patent application should be like a protocol, a recipe book for the experiment. So somebody else, like one of your colleagues outside of the lab, can make and do exactly what you did and achieve substantially the same results or similar results. And I know you've seen me write that in an email when I've asked you to review it, because the concept of enablement gets a little tricky and a whole bunch of legalese, and it's really, if somebody else can do exactly what you did and achieve substantially the same results, then.
So if you hide an essential element of enablement, then you invalidate the patent. Is that correct?
Well, you possibly will not receive patent protection because you have a duty to disclose the best mode. You must disclose the best mode. Right now, you can't later on invalidate a patent for not providing the best mode. But still, the best mode exists as a requirement, and what it means is that you might not be able to get the patent granted in the first place if, one, you didn't disclose the best mode. But later on, the way a patent could be invalidated for lack of best mode is if you intentionally withheld it, and so you did this deceiving act, and then based on that misconduct of doing it intentionally and not disclosing the best mode, it's the misconduct that can then be used to invalidate the patent.
Okay, I have more questions here. Are surgical techniques intellectual properties?
Yes, can be, because it's know-how. It also might be patent eligible. But the issue that one would be facing in looking at whether or not it's commercially viable is if one could enforce, say, patent rights against someone who's doing that surgical technique. And so for some investigators who come to their tech transfer office and say, I have a surgical technique, well, then the question is, well, is this really commercially viable? Is somebody going to license it? And if they do, and we pursue patent protection, can we really restrict people from doing that? And
how are we going to go into the operating rooms to make sure they don't use your technique?
And you can't, because doctors are, exempt from being held liable from infringement for practicing medicine. So.
And we also, that's our biggest problem with methods, is enforceability. With just patenting methods. And as a state institution, the state of California, we're not going to chase after people for producing methods that we generate, because that's our role in the state, is to promote innovation, promote health and techniques.
For some methods. Other methods, it's really hard to prove that, say they made this compound or this composition by your better method. Some are almost impossible to prove during litigation. That's what you'd be looking at, is can we really enforce it?
So is there a clear-cut definition who is an inventor? Because when you say someone is an inventor and a non-inventor, there are a lot of overlap between an inventor and a non-inventor. Is there any?
There's not overlap between an inventor and a non-inventor. It's clear and distinct who is an inventor and who's not an inventor. I think I might not have been talking clearly. Investigator, so I was using the term investigator.
No, I think his question is more elaborating. If somebody working for a PI as a postdoc, for example with Tom Grant, and they found some technique, Tom Grant want to patent something, and he does not want to put the name of the postdoc. How can you decide anybody? For example,
first of all, that's not his decision, and I don't care who you
No,
are, Dr. Sands, but if you ever do that,
I don't want it to be my
I'll
decision.
disclaim you. But that is the role of the patent attorney. You know, we ask like, okay, and it's based on the claims. What is being claimed? And so if there is a question, we need to know about it. If say even like say a postdoc, I mean this you guys might get flooded with calls now, like a postdoc who feels like he wasn't named on something, might be afraid of even going to the, you know, Dr. Yans and like saying, hey, you know.
My postdocs are not afraid.
We're terrified.
Go talk to the TTO. You know, the PIs, the tech transfer office isn't just for the PIs of the lab or, you know, faculty. I mean, go talk to them.
In principle, it's technical help that doesn't provide intellectual contribution. They're not an inventor.
If they were, as in technical help, just told to do and they just did and nothing else, didn't analyze the data, didn't add or try to solve some problem with actually even like running the experiment, that it just was like, they just did, they are not an inventor.
But if they did analyze the data, then they would be considered.
If I mean, you know, now you get into, well, what type of data did they analyze and when? Right? So did that analysis result in conception of the invention? Did it play a role in the conception and reduction to practice? So.
That's the important thing, is the conception of the idea. I mean, Robert's here, and we had an incident where he identified a chemical database of which the original compound came out of. That's inventorship because of the original concept, basically. So he was added as inventor.
I have one last question.
Ask away.
And nobody reads your provisional unless you refer to it in the patent application, right? Can your provisional be used against yourself as prior art?
That is so loaded. So I'll start dissecting it myself.
Yeah.
So there is a reason why we don't want inventors to reference provisional applications and say publications and on the resume and all that stuff, because once that serial number and information is out there, that they can obtain, others can obtain certain information about that application and the status, and you know, a lot of times that's just not good, or why should we even do that? Now, once that patent, if there's a utility application, claims priority to a provisional, and once that is published and you just published, but then granted too, once that's cited in another application, a utility application, that anybody then can obtain that provisional application, read it, see what's in it, it's out there then. That provisional can also be used as prior art. It can't be used as prior art against the timely filed utility that claims priority to it, but it can be used as prior art for a later application on another invention that's filed later on. And so.
Okay. I think, are there any more questions? Any other questions? Very instructive. Thank you very much.
Thank you very much.
So let's have